Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome back to Global Happenings Today YouTube channel. For a while now, there have been disquiet in the camp of the Agbadorians, those who have been standing strongly on the mandate of BAT over the 42 pages final written address coming from Labour Party Peter Obi's lawyer. What they wrote is very simple, very understandable, very straightforward, and very powerful. Talk about tackling. Talking about technical knockout, you'll not be far from it. We're going to give you full highlights. We gave you a little of it some few hours ago. We give you the key high notes that was written there that caught the attention of many, and that many of those in the opposition and in the main ruling party have been looking at that 42 pages write-up. Hey, it's worrisome. But before we go into the news proper, I would like you to subscribe to our channel by clicking on the red subscribe button. Beside it, you see bell notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, in Peter Obi's final argument challenging the declaration of Bola Ahmed Tinubu as president of Nigeria, Peter Obi has asked the Presidential Election Petitions Tribunal to answer one question. Can Mr. Tinubu sustain an argument that he didn't personally suffer economic sanction when he forfeited $460,000 to the United States of America in the 1990s? When money was money. Let's continue. The question has become central as the tribunal receives final arguments from parties in the lawsuit ahead of its final judgment due in a few weeks. Mr. Obi is seeking to disqualify Mr. Tinubu as ineligible to stand for election because he forfeited funds to the United States after that country's authorities identified him as a launderer of ill-gotten proceeds of narcotics peddling in Chicago. While there are several other grounds being pursued by Mr. Peter Obi, all trained towards removing Mr. Tinubu as an illegitimate president, a particular section of the Nigerian Constitution has received perhaps the most rigorous attention. Section 137, subsection 1D said, among other disqualifying grounds, that a person shall not be eligible to run for president if the person had been previously placed under a fine by any court or tribunal. The United States District Court for the Northern District of Illinois had on October 4th, 1993, ordered the confiscation of $460,000 owned by Mr. Tinubu, who has lived in the United States for decades preceding the judgment. The funds in the amount of $460,000 in USD, of course, in account 263226700 held by First Heritage Bank in the name of Bola Tinubu represent proceeds of narcotics trafficking or were involved in financial transaction in violation of 18 USC 1956 and 1957, and therefore these funds are forfeit to the United States pursuant to 21 USC 882 subsection A, subsection 6, and 18 USC 981, the judgment delivered by late jurist John Nordberg said. Mr. Tinubu's lawyers, while admitting that their client was indeed the subject identified in the judgment, have argued that the forfeiture was a civil procedure and should not come under the definition of fine as prohibited in the Nigerian Constitution. But Mr. Peter Obi's lawyer, while citing a flurry of case laws in and outside Nigeria, said there should be no ambiguity in the interpretation of a forfeiture as synonymous with fines. A civil forfeiture in the United States amounts to a fine or a punitive economic sanction, and it is also at least partially punitive against the persons whose property is affected, the legal team led by Levi Uzokwo argued. The lawyer said the Nigerian Supreme Court had defined forfeiture as a form of punishment for an for an offense in a January 2014 majority verdict delivered by Kayode Ariwola, now the Chief Justice of Nigeria, Kayai. While ruling in the matter of Mohammed Abacha against the Federal Republic of Nigeria, Mr. Ariwola cited several definitions of forfeiture and concluded that, and I quote, "These definitions leave no doubt that the forfeiture is a sanction, a fine by the court. It is penal and criminal in nature." Hey! They also cited a February 20th, 2019 decision of the United States Supreme Court which accepted that a man whose vehicle was placed under forfeiture by the state authorities in Indiana had been excessively punished via civil forfeiture. The American top justices defined the civil forfeiture Indiana imposed on Tyson teams as a fine that violated that country's 8th Amendment excessive fines clause. Protection against excessive punitive economic sanctions secured by clause is, to repeat, both fundamental to our scheme of orderly liberty and deeply rooted in this nation's history and tradition, the court said of civil forfeiture. The Nigerian Constitution only stated that a person who had been fined before shall not be elected president and did not say whether or not the forfeiture should be through a civil or criminal proceeding. Yay, this one is technical knockout. Let's continue. Now, Mr. Obi's lawyer said several dictionaries dating back to the 18th century have always defined forfeiture to also mean a fine, and in 2019, U.S. Supreme Court judgment proved that the definition still endures. Consequently, upon the team's ruling, they argued that Mr. Tinubu cannot successfully claim that he didn't suffer any losses when the United States authorities seized the $460,000 from him in 1993. Why did teams challenge the forfeiture proceedings if he was not to be personally affected? They asked. Mr. Obi's lawyer said, can it be honestly argued that the second respondent, which is Mr. Tinubu, herein did not suffer economic sanction when he forfeited $460,000 to the U.S. government? Question. Mr. Tinubu's lawyer promptly dismissed the argument as counterproductive to Mr. Obi's case because Mr. Timms had pled guilty to narcotic businesses and was sentenced to jail before the forfeiture proceedings was introduced into the matter by the state government. But Mr. Obi was only seeking to establish that courts in Nigeria and the United States of America accepted the definition of forfeiture as also constituting a fine in order to satisfy the Constitution's specific mention of fine as sufficient ground for disqualification, on argument Mr. Tinubu's lawyer did not address. Mr. Obi's July 20, 2023 written address came days after Mr. Tinubu argued in his written address that the U.S. forfeiture was not sufficient ground to nullify his presidential victory. He also threatened that there will be anarchy should he be removed from office on the basis of his failure to get 25% of votes cast in Abuja, a statement that was widely condemned and which Mr. Obi's lawyers addressed in their written address as unfounded because the Constitution was clear on the 25% vote requirement in the nation's capital. We have recently deactivated. Okay, but let's continue. A lot of Nigerians have been reacting to this. A lot of reactions are playing out. If you check the very first part we read over the final written address, it would address the issue of anarchy, the issue where the legal team of Tinubu did mention the fact that if they didn't get the 25% that for whatever reason Bola Tinubu is removed, it may cause anarchy. They addressed it in the first leg. This is the second leg. This is 42 pages. So we are trying as much as we can to give you. This one is technical knockout. Very simple English. There's no big legal terms like the teaching person, and I quote, there's no quotation. This is lovely. Let's put in that conversation. Nigerians are just reacting. Let's feel you.